does abuse of discretion work with respect to a pure legal question?
I think this Court answered that both in Pierce and Cooter. It said if it's a truly pure legal question, then it is that there isn't deference given to that in that circumstance. Now, here the question presented is objective baselessness. And in the context of Section 285 determinations, that kind of retrospective look, was the attorney acting reasonably or not? Pierce and Cooter both say that's something that is always context-dependent. It always depends on the facts.
Well, could you explain that to me a little bit, Mr. Katyal? In a case in which the district court just uses an erroneous claim construction, you would concede that that's a pure legal question, so that would be an abuse of discretion?
We would not, Your Honor. So certainly on the merits, if the question of claim construction went up to the Federal Circuit, as it did here, for example, in 2009, the question there would be no deference under the Federal Circuit's precedent, and most recently Friday in the Lightning Ballast case. But when the question is a 285 question, the retrospective look at objective baselessness, of which claim construction forms a part.
No, but I guess my first question was just if the district court says, here's the appropriate claim construction, and in saying that, it's wrong.
Yes.
Is that a legal question?
As it goes up to the Federal Circuit under existing precedent, they treat that as a legal question. We think this Court's decision in Markman suggests otherwise. It said it was a mixed question, a mongrel question of law and fact. And so if the Court were ever to get into that ultimate question on the merits, we think that the Markman analysis would control. But here the question is a 285 question.
To every legal issue that's raised on appeal. Well, if you have to decide whether the lower court was right, that's a lot of work. But if all you have to decide is whether the lower court abused its discretion in deciding that the law means what the lower court said it means, that's a lot less work. Well, that argument is a strange argument. Unless there's something really special about the attorney's fees context. And I guess that's your argument. There's something really special. But why should it? When you've got a lot of money involved, why should we say this is collateral litigation, even though it involves millions of dollars more than the claim in many other types of cases?
So let me say a couple of things about that. And one is, I think ordinarily when an appellate court applies a de novo standard and determines what the right answer is, that has benefits not just for the particular litigants before it, but also in clarifying the law for everyone going forward. But what the Court said in Pierce and in Cooter and Gell, and what's also true here, is that when the question that the appellate court is answering is not what is the law actually, but rather what could a party, when it initiated this case and continued to litigate it several years ago, could that party have reasonably believed the law to be, that doesn't yield the same sort of law clarifying benefit. In fact, in Pierce, this Court said those sorts of determinations are never going to be made clear under any sort of
It can clarify the law. What's the difference between that situation and, let's say, deciding an issue of qualified immunity in a civil rights case or applying AEDPA in a habeas case? The Court can say this is what the law is, and then after that, as the second step, determine whether a particular interpretation of the law was reasonable. You could do the same thing here.
A court could do that here, and I suppose the Federal Circuit, if the case came to it on the question, was the district court, did it abuse its discretion or did it get it right in deciding that the party's position was unreasonable, the Federal Circuit could decide the underlying question itself and then decide whether or not the district court was correct in concluding that a party's position was reasonable or unreasonable. But we think there's good reason not to do that here, and we think that in these contexts, unlike in qualified immunity, unlike in AEDPA, the district court has particular expertise in the case and a long experience with the case, and that requiring the Federal Circuit to engage in a thorough review of the entire record of the litigation and the entire proceedings of the litigation imposes a burden that just isn't justified.
With respect to winning or losing the case, you're going to get de novo review. Because the Federal Circuit here looked at the claim construction, under de novo review, agreed with the district court that it had construed the claim properly and that you lost. So you got de novo review. the issue on a reasonable ground to pursue the litigation, whether it was objectively reasonable or not, I think that's Justice Breyer's point, which it generally has factors that are independent of winning or losing. And that's why I kept going back to what the district court said in this case, which you seem to ignore. It at one point recognizes that your claim was a difficult one, but it says that doesn't excuse the fact that you maintain the 52C claim, the one at issue here, even after both the special master and your expert had said a particular claim wasn't sustainable. And it continued with a long example of examples, multiple ones, that it found unreasonable, having nothing to do with the ultimate reasonableness of your last argument before the appellate court. So, again, I ask the question, why should this objective reasonableness be considered a pure question of law? Because it's not about right or wrong and legal answer. It's about behavior during litigation.
Your Honor, there are two facets to the answer I would give to that question. One is that all of the points you made about what the district court found were not issues on appeal. The district court found lots of things, but the four issues that went up on appeal did not deal with all the facts you're talking about. They dealt with legal issues. There was no pre-filing investigation issue. The Federal Circuit expressly found that in a footnote in its opinion. There was no pre-filing investigation issue in the final decision on appeal because the district court made multiple decisions. One was a Rule 11 decision in which he didn't provide a safe harbor for anybody. And we went in and we asked him to reconsider it, and he changed his opinion and dropped everything against the attorneys. What went up to the court were four issues, and they were four legal issues. And all I'm saying is that Scott versus Harris and Justice Souter, in a concurring opinion in the PRE case, said the same thing, that objective reasonableness is a legal issue, reviewed de novo. And if you want uniformity, if you want predictability, the best way to avoid chilling not only patentees but accused infringers from being willing to go to court for fear that they may have to pay $30 or $20 or $10 million, and the accused infringer from defending against it, is to have predictability, to have uniformity in decision-making, which you get from having a single court reviewing those cases, and that single court is the Federal Circuit.